If everyone is ready,
You're good.
it is now after 9 a.m. on September 15th, 2022, for the special meeting of the Cannabis Compliance Board. Formally call the meeting to order. If we can have a roll call of the board members.
Member Merritt,
Present.
Member Durrett.
Here.
Member Nylander,
Here.
Member Young,
Here.
and Justice Douglas.
Here. That would take us to item number 1, public comment today. Good morning.
Good morning. Paul Michael Burgess for the record. Good morning, Chairman Douglas, distinguished board members, Executive Director Climas. I give my public comment today on the dangers and public health of cannabis Delta 8. Delta 8 has been in the news and every publication and magazine in the nation. We just had in the nation some middle schoolers taking some gummies, and they were, had to be sent to the hospital. I've sent them before, and I presented myself before this board on a mobile application that would work in this area. This is also something the FDA, the NIH, and the CDC has been known that this is a public health, national health alert and emergency. Just presenting this, I've sent a document in, I've sent a demo in. I would gladly, meet with the board or do a demo for the board of what this application would look like in a demonstration, and how this could be a benefit to the CCB, the state of Nevada, and also for the public health and community of cannabis. So just wanted to bring that back to the attention of the board, and thank you for your time.
Thank you. Anyone else in Las Vegas wishing to make a public comment this morning? No one else coming forward in Las Vegas. Do we have anyone wishing to make public comment in Northern Nevada? Good morning.
Good morning, Chairman Douglas, members of the committee. Senator Pete Goycochea for the record, Goycochea. And if I could have just a few minutes of your time to bring forward an issue that is facing or is appearing in rural Nevada, especially northern Nevada. Most rural communities and jurisdictions were very apprehensive, as I was, with when cannabis was in fact made legal. We were concerned about the impacts they were going to have on our communities. But now, 5 years later, it is becoming apparent there is an economic benefit, and at the least, you guys are doing a good job in controlling it, I believe. But as we move forward, I believe it was legislatively intended that every jurisdiction could and would have access in a limited way to licensure. It has come to my attention that White Pine County has in fact petitioned the board for a medical cultivation cannabis license, and it hasn't been moving forward. I know there are some other jurisdictions that are also anticipating or going to come forward with an application, and I understand in the legislation, it was clearly intended, although very limited in a limited number, that those communities and those jurisdictions wouldn't be shut out. And so I just want to bring that to the board. I'm only one of 63, but I do believe that was our intent, that every jurisdiction could at least access some type of licensure, and it wouldn't all end up in the rural areas. If that is not the case, then I'm requesting that you do, in fact, promulgate the regulations that would be required. These communities did not put in the first round, but now we're 5 years later. It's becoming apparent that there is an economic benefit there. And I feel legislatively in the legislation, it did say they could access at least one license per jurisdiction. And again, whether it was cultivation or a retail recreational license, they still have to have the ability to access that by the legislation. So I'm just asking you, please take a long, hard look at this. We have a particular company in White Pine County that I know the Board of White Pine County Commissioners has endorsed and petitioned for their licensure, and they are struggling. It'll be a huge impact to the tax base in White Pine County if this doesn't happen. And I think as we move forward, you're going to see this coming out of other rural jurisdictions. So I thank you for your time. And again, I realize you can't question me from here at the dais, but if you have any questions on this, please call me. The board has my phone number with my card. And I thank you. I'm probably close to the 3 minutes. Thank you, sir.
Thank you. We have anyone else in Northern Nevada that wishes to comment?
No, Mr. Chairman, I see no other public comment in Carson City.
With that, we would close public comment at this time. And that would move us to item number 2. Consideration of pending motion in the matter of Cannabis Compliance Board versus Cannabis Nevada LLC, now known as Tusatex.
For the record, Kimberly Maxon Rushton, in response to your question, Douglas, excuse me, Chairman Douglas, it's Let Us Test, LLC.
Thank you.
And we go by the acronym LTL.
Thank you. With that, Ms. Rushton, this is your motion on behalf of your party.
Thank you. Again, for the record, I'm Kimberly Maxon Rushton with the law firm Cooper Levinson, appearing on behalf of Let Us Test LLC, otherwise referred to as LTL, or the respondents. In addition to that, members of the board, I also wanted to let you know that another acronym that is commonly used and that I'll probably use during the course of my arguments is an SOD, a statement of deficiencies, as well as a CAP, corrective action plan. So just wanted to put that on the record. And again, if I move too fast or if there are any questions, please don't hesitate to let me know. Joining me today on behalf of the respondent are the owners, Mr. Rob Richardson and Mr. Rick Rushton, as well as the scientific lab director, Dr. David Luttrell. As the commission knows, the single most important function of any regulator is compliance. You must ensure compliance to ensure the safety of the industry and the consumers that use the products of the industry. It is also the single most important criteria for any licensee in a privileged license capacity. And that's established not just by tradition of administrative law, but specifically in Nevada Revised Statute 233B, which is referred to as the Administrative Procedures Act. And that act was in place when this matter occurred. It's important to note for the record that every single one of the acts alleged in the 2021 complaint occurred in 2019. What's also important to note, is the fact that each of the allegations were remedied by the respondents, either at the time of the 2019 audit, investigation, or inspection, or immediately thereafter upon the receipt of a statement of deficiencies from the then Marijuana Enforcement Board. And based on that, the respondents' immediate actions and drafting and submission and completion of a corrective action plan met the legislative standard, the law at the time under NRS 233B, which specifically requires compliance. If you look at the law, it states that an agency may not initiate actions to revoke or suspend a license until they've given the licensee the ability to demonstrate compliance. That same law goes on to say that if the agency believes that there is an imminent threat of safety to the public, they may issue a summary suspension as part of the disciplinary process. And that framework is important for you to understand, because based on that, we respectfully submit that this case is over. When the respondents immediately acted during the audit at the request of the inspectors and thereafter immediately responded to the statement of deficiencies and undertook 16 steps to demonstrate.
Ms. Rushton, I'm going to cut you off at this point and I'd like to direct you to the purpose of this motion for consideration, not the re-argument of the motion itself, your motion to dismiss itself at this point. We are aware of that pendency, what is before us, but tell us why we should give consideration to allowing you to argue the dismissal that the ALJ, administrative law judge, determined that's also part of your objection
Certainly.
separately.
In response to your questions, Justice Douglas, the basis for the request for the consideration of the motions to dismiss is based on the long tradition and the procedural history of cases whereby the courts will regularly entertain what we call dispositive motions, motions to dismiss in advance of hearing or going to trial or to an evidentiary hearing. And the point of it is to avoid the obligation to go through a lengthy trial if the moving party justifies the basis for the dismissal of the action. In this case, the dispositive motions were ordered by ALJ Smith to be filed by March and beginning of April of 2021, 14 to 20 days in advance of the evidentiary hearing. And yet, even though those motions were filed timely, they were not considered until moments before the hearing, which defeats the purpose of having dispositive motions filed in advance of the hearing. In all other instances, I would respectfully submit that the objective is to hear those motions in order to avoid, again, going through a lengthy hearing. And because of the nature of these specific motions, one based on claim and issue preclusion, which is otherwise referred to as res judicata. We finished this matter, it's been completed. We don't need to go any further. The other basis was what we call laches. The complaint was filed in 2021 after the matter had been completed, evidence was lost, witnesses were gone, there was a material change in the law. The third motion to dismiss, or the second motion to dismiss, and the third claim was the jurisdictional claim as to whether or not this body has the authority to reach back into another agency's now repealed laws and prosecute licensees for violations. Specifically, when NRS 453 A and D and NAC 453 A and D were repealed, how do you go back and now charge a licensee with regulations that have been repealed? And the argument was that there was no saving clause, and I believe that that's set forth completely in the motions. The motion to consideration, or for consideration of hearing the dispositive motions, was done with the same intent, that you would hear those motions prior to launching into an evidentiary hearing on the disciplinary actions. And because of the nature of those motions, they warrant reconsideration by this board. The other point is the fact that the ALJ did not do her job, respectfully speaking. And what I mean by that is not only did she fail to hear the motions in advance, I mean, she literally heard them minutes before we started the hearing, inferring that she had either A, made a predetermination, or B, didn't really care about the substance of it. But when she did rule on them, she gave no specifics. She specifically said, doesn't meet the criteria of claim and issue preclusion, doesn't meet laches. That's it. And then stated that with respect to the repeal argument, the jurisdictional argument, she pointed to one section of a 173-page bill, a legislative bill, and said that section means that they could go back and prosecute you under the regs that have been repealed. We respectfully submit that the analysis that is required relative to claim and issue preclusion as well as laches is a very substantive process. There are multiple factors under the claim and issue preclusion that need to be addressed and analyzed, and there are even more under the laches. In fact, in the seminal case in Nevada, the appellate court for the state of Nevada specifically stated that a laches determination is an involved analysis. And therefore, the fact that the ALJ in a one-line statement said it doesn't meet the criteria doesn't give you, as the reviewing board, the only body able to make a decision on this case, any insight as to what her thought process was. And so I'm asking for consideration for two reasons. One, The ALJ does not have jurisdiction and authority to rule on dispositive motions. The board is the only body that can rule on a complaint. You're the only ones that can uh, basically dismiss a complaint or otherwise impose a fine or other criteria that you believe are necessary on a licensee. The law is clear. There's no ambiguity there. But in this instance, the ALJ reviewed the motions to dismiss and ruled on them, and then gave you an incomplete ruling. In fact, it's not even included in the findings of fact conclusions of law. It's simply in the transcript. And so it's as if, again, her decision may be a recommendation for your consideration, but that's all it is. It's a recommendation, and I would respectfully submit that it's an incomplete recommendation, thereby warranting not only consideration of the motions to dismiss, but full consideration of the motions to dismiss, and not based on her recommendation, because there was no substance to that. And so for those reasons, members of the board, I would respectfully request that you entertain the motions to dismiss and allow us to proceed with those before we launch into the disciplinary hearing relative to LTL. And I'll reserve the rest of my time for rebuttal. Thank you.
Can we have counsel for the compliance?
Good morning, Chair, members of the board. Christopher Rath, Senior Deputy Attorney. I'm going to address the Chair's initial question as to whether these motions should be heard today. And then I can go on and discuss the second motion to dismiss, and Ms. Balducci will briefly discuss the first motion to dismiss. First of all, these motions should not even be heard today. This is an administrative action. This is not a civil action in the district court. I would point out that NCCR 4.125 does allow for motions. This does not specifically allow for dispositive motions. Moreover, the important statute, well, in any event, both sides under the regulations have the right to present their evidence and argument at hearing before the hearing officer first and before the board disposes of the charges. Granting any dispositive motion before that deprives the party of those rights. Most importantly, if you look to NCCR 4.135, that is entitled Disposition of Charges Adjudication by the Board. Under that regulation, the disposition of the charges is only to be done at an adjudication in which the board hears from each of the parties. That regulation does not say that the charges can be disposed of by motion alone. So it does not specifically even provide for dispositive motions. Therefore, the motion should not be heard today. If the board chooses, it could consider the arguments at the final adjudication, and only after the final adjudication can a final order be issued on everything, and only that final order would be subject to judicial review. In fact, subsection 5 of NCCR 4.135 says within 30 days after the conclusion of the adjudication by the board shall issue a final order that imposes discipline and incorporates the findings of fact and conclusion of law obtained from the hearing. So I think this motion for consideration is basically an end around to try to get an interlocutory judicial review, which is completely inappropriate. I'll point out that there was a recent case, a similar case, Nevada Gaming Commission versus Wynn in March of 2022. It's 507 Pacific 3rd, 183. In that case, Mr. Wynn filed a motion to dismiss for lack of jurisdiction and administrative action before the Gaming Commission. The Gaming Commission denied that. Mr. Wynn then tried a judicial review, which was denied because there was no final order from the commission. Likewise, in this case, there should be no final review until there should be no judicial review until there's a final order after the adjudication.
Counsel, you cite that case, but where we're at with this is that that argument has not been made to the board yet. It's been made to a hearing officer,
Correct.
administrative law judge, for recommendations.
But that does still follow our regulation, which our regulation does indicate there has to be a final order, which can only occur at an adjudication in which both sides get to speak before the board. The disposition of charges cannot be done by motion alone. So I think that's in the plain language of our regulation. I'm going to go ahead and argue the second motion to dismiss because I assume you want to go ahead and hear our arguments, or
From a posture standpoint, we need to make a decision as to what's been requested first before we make a decision whether or not we're going forward with anything else today.
thank you, Your Honor. So we'll submit on those arguments.
Thank you. Ms. Rushton?
I'd note for the record the fact that pursuant to Nevada law, specifically NRS 678A.600 and 678A.610, authority of an aggrieved party to seek judicial review of a final decision or order of the board. That demonstrates there that the ALJ, administrative law judge, does not have the authority to rule on dispositive motions. And she set forth a procedural order that said filings of dispositive motions must be filed by this date. We filed them by that date, and it was consistent with Nevada rules of civil procedure, whereby it was done 14 to 20 days in advance of the hearing. So therefore, the expectation of the respondents was that those motions would be considered prior to the hearing. And what's important about this, and I note the fact that different administrative agencies handle this matter differently. Some of them allow the ALJ to review the dispositive motions and to make a recommendation to the full board. Other boards instruct the ALJ that they are not allowed to do that because, again, any final decision on a disciplinary matter can only come from you, can only come from the board. And therefore, in this instance, her decision to allow the filing of the motions to dismiss in advance of the hearing, the expectation was that she would rule on those before we launched into a 21-day hearing. Instead, she heard the motions in the morning, said we would come back after lunch, made a 2-minute ruling thereafter on the record. We specifically asked, Mr. Carson, my co-counsel, and I asked the ALJ if she would then produce an order so that we could take it up to the board. Our objective was that if we got a recommendation from her, we could then bring that to you. And again, with the objective that if you believe that the motions to dismiss should be granted, we would not have to go through the exercise of 21 days of hearing. And that's the point of having dispositive motions. We believe that A, the matter was completed, we shouldn't even be here. B, that if it wasn't completed, that they took too long and it prejudiced to a point that we could not properly defend ourselves. And C, that the law doesn't allow you, because of the jurisdictional issues specifically stated in Assembly Bill 533, repealed 453A and B, and they no longer exist. The law is very clear that you are the only body that can make a motion on or decision, on dispositive motion. As I indicated before, you're the only one that can impose a fine. You're the only one that can dismiss a complaint. There is no reason for you to move forward with a complaint when there are solid legal grounds for dismissing it, especially when you consider the fact that from the very beginning of this matter in 2019, compliance was demonstrated. It is a fundamental obligation of both you, the regulator, and of the licensee to ensure compliance. And when they did that, this case should have been ended. And so for those reasons, we respectfully request that you consider the dispositive motions in advance of the disciplinary hearing so that you have a right to understand really the basis of this case and avoid the obligation to go through a lengthy hearing when it should otherwise be disposed of based on the fact that A, it's too long, it's been completed, and or there is a claim with respect to a jurisdictional infirmity. I'd also respectfully submit to you that the second motion to dismiss that does pertain to the judicial infirmity is an important matter for this body to consider. You have imposed fines on individuals for failing to file timely tax returns from as far back as when the Marijuana Enforcement Division was in place. The Department of Taxation took no action against these licensees, and yet this body is taking action. And I'm respectfully submitting that you don't have that authority. 453A and D were repealed when you promulgated the new regs. And on August 5th, when those were adopted by the Secretary of State, the law is clear. 453A and D, both statute and regulations, went away. And so for those reasons, again, we would respectfully request not only that you consider the motions to dismiss, but obviously that those be granted as well. And as always, members of the board, I'm happy to answer any questions that you may have.
Any board member have any questions?
I have a couple concerns. And these are just related to the motion to consider, not the motion to dismiss. Oh, I think these are actually for the AGs. Yeah, I have questions for the state.
Ms. Melton, before you sit down, in what you just presented, you made a comment at some points related but unrelated to this hearing as to the ability for this board to deal with outstanding tax issues. We have a licensing. If a party doesn't meet all the requirements to be licensed and has an outstanding issue, we can deny the license. So for this board to wish to make sure that they are meeting the obligations of the license, one of the reasons why the people of the state thought it would be wise to allow marijuana, that they need to be in compliance. And if they're not, it's our obligation to make sure they are, or in the alternative, to deny their license or the renewal of the license.
Yes, sir.
So I think that's a little outside the box of what we're here for today. But I understand part of your argument pertaining to why we're here today. With that, we had a question by a board member directed to.
Thank you. I do. Oh, I'm sorry. Max and Rushton. I do have one question. So the state made the point that if this is disposed of by dispositive motions, then the parties don't get their right to a hearing. What do you have a response to that?
In response to your question, Member Durrett, we've already gone to hearing. We had 21 days of a hearing, and that occurred back in 2021. And so the motions to dismiss were filed in March prior to the initiation of the hearing, which started in April, continued until June, and then continued again until November. And so those motions have never been raised before you until now.
But the parties get a right to hearing before the board. So if it was disposed of with the motion, with the dispositive motion, then they wouldn't have, then would that cut off their right to a hearing?
Yes, ma'am. So if the motions to dismiss are granted, just depending again on your ruling and how extensive it is. I mean, we're requesting complete dismissal of the complaint, the 2021 complaint. So there would not be any hearing. Now I will note, and again, I think it's important because it's a matter of semantics, but the complaint and what we believe constituted the disciplinary action in 2019 and 2020 are identical, save and except for 4 counts. So one option the board could decide is the fact that, yes, we believe you demonstrated compliance with all of these particular violations, but these 4 were not in the summary suspension in 2019 or the statement of deficiencies issued in early 2020, and therefore we're still going to have the hearing on those 4. So you have options.
Thank you.
That is where the latches argument goes, though, with respect to, and of course, the claim preclusion, Member Durrett, with respect to known or should have known what the violations are. And our position is that they clearly knew what the violations were when they left on December 11th, 2019, following the inspection. Therefore, that should have been the initiation of the action.
Got it. Thank you. And then I do have 2 questions for the state. I thought in the pleadings that I read that the state agreed that the motions to dismiss should be heard. It's just there was a dispute about the timing of the motions to dismiss.
That's partially correct. And I want to note also that there was never any objection from this side to the hearing officer hearing these motions to dismiss initially until they lost them. But to answer your question, there's no disagreement that they can make this argument or these arguments at the adjudication, which is where they should be made. Again, the adjudication regulation indicates that both sides get to present their case. They can argue that the hearing officer was wrong about the motions to dismiss, but that should happen at the adjudication. Our regulation does not indicate that you can dispose of this case simply by motion alone. It gets each side to present that. And now if it's decided today and it's granted, then we lose our right under the adjudication regulation to present our case at the adjudication, which is clearly in the regulation.
Well, one follow-up question. Isn't that very wasteful to hear the motions to dismiss the same day as the adjudication? Because if you grant the motions to dismiss, then you don't need to have weeks worth of hearings and testimony and, do all the discovery.
Are you referring to the hearing officer hearing the motions to dismiss?
Just in general, both, because the argument is both for the same, right? That you can't do a dispositive motion in advance of the hearing, that you have to do it the same day. So,
Well, first of all, I think there was a lot of motions flying around, and my understanding is we all agreed to have them heard at the start of the hearing. It's my recollection. And they were able to fully argue and brief those motions before the hearing officer. Had the hearing officer granted those motions, we would still go to an adjudication because the board's got to make a final decision. So the hearing officer denied the motions. We had our hearing, which, most of these hearings should take a day or two. This one took 20, unfortunately. So that all had to be done to get to the adjudication.
they could have made a recommendation to the board to hear the motion to dismiss without going forward with the adjudication, right? That is an option. That's my last question. Thanks, Chair.
I don't know that there's an interlocutory appeal in the process. So the hearing officer is going to decide, hey, I'm granting them, and then that would go to the board because she wouldn't hold the hearing. Or I'm not granting them, so let's hold the hearing, and the board can sort it out all at once. So it's sufficient for the board to sort it out all at once. It's our position.
Thanks.
Any other questions?
Hear no other questions.
Thank you.
At this time, since unlike other tribunals, we are not necessarily allowed to go in the back and convene among ourselves. We have to convene on the open record as to our position as to what is before us this day, as to the motion requesting consideration of LTL's dispositive motion prior to disciplinary hearing. So if any board member wishes to share thoughts, we are.
Mr. Chairman, this is Member
Yes.
Nylander. I apologize. I have a question for Ms. Rushton.
Thank you.
Good morning.
Good morning.
So I've read the transcripts, and so are you arguing that you didn't have an opportunity to present your motion, your dismissal questions before the ALJ? Or are you
In response to your,
just too much timing, is it?
in response to your question, Board Member Nylander, our position is that the ALJ does not have the authority to rule on a dispositive motion. And as I indicated earlier, I don't dispute the fact that she could hear them and make a recommendation, but the decision as to whether or not they could be granted resides solely with the Cannabis Board. Ideally, I think the procedure should have been that if she determined that she was going to consider them and rule on them, that she would have done as we requested, that was issue an order at that time so that we could have taken it up to the board and avoided going through 21 plus days of hearing and everything based on the fact that the motions were ripe for consideration in terms of dismissal. And so, long-winded response to your question, our position was that she could make a ruling or a recommendation, but that had to be immediately transmitted to the board and should have been, so that in the event that the board grants the motions, we could have avoided otherwise a lengthy hearing on the matter.
Yeah, but I guess I'm asking is, I mean, you had an opportunity to brief the thing. It looks from the record.
Yes,
There
sir,
was
that
a
is
full
correct.
briefing and full oral arguments, and then she rendered her decision.
Yes, sir.
Okay. I understand. Thank you.
Yes, sir.
Any other questions? Thank you. Any board member wish to share their thoughts at this point for in discussion?
I would much rather the more seasoned attorneys weigh in first, but since there's silence, I just want to put out there that I, pretty much regardless of any of the arguments, would want the opportunity to ask questions of the parties on the motion to dismiss. I don't think that, I don't know, I'm not saying the ALJ did anything wrong. Like I said, regardless of the arguments, I, as a board member, want to ask questions about these motions to dismiss that weren't covered by the ALJ.
Yeah, so, and this is member Nylander. I think, we should grant the initial motion to consider it and then, see where it goes. But I do think the record, at least from reading the transcripts, the record is pretty clear. But I guess we're going to have to deal with this either on the merits or no or now. So, and again, I think the record is clear. We don't have a written order that's in the final ALJ order, but it clearly was considered at the time and briefed by both parties, and there was full oral argument on it and a decision. So
Chair Douglas, for the record, having looked at this, I take the position that we should consider the motions. They'd be allowed to do so. A note for the record that, as was indicated, a hearing was held by the administrative law judge. Motions to dismiss 1 and 2. That was considered. The hearing officer ALJ made a decision that's on the record, and looking at our various legal authority, the administrative law judge or the party is to either make a written order or make a decision on the record. So we have a decision on the record. But again, it begs part of the question. Part of the question is that fact. What was done by our hearing officer, administrative law judge? They provided us with findings of fact, conclusions of law, and recommendations. The last word being most important, recommendations. And the parties have a right to dispute those recommendations if they so see fit. Which then brings us back to the original reason for bringing these motions to dismiss in the first place. Normally, if it's judicial proceedings, we talk about judicial economy, not going through as Russian talk about a 21-day or 18-day or whatever hearing. If it can be, issues can be sorted out prior to a full trial or a full evidentiary hearing. So before this board hears the full objections and the positions of the parties as to the recommendations this board is going to have to consider, I personally think it would be more appropriate for the board to hear the arguments made by the parties as to why or why not those motions should or should not have been granted. But that's my position. We are kind of in a strange area that the law is clear, but it's not clear as we are an institution going forward, because there are contradictory things. And unfortunately, at least my read was the record is not as clear as it should be in terms of what parties advocated and meeting certain burdens to get the results that were gotten. So with that, I think it's appropriate, as Member Direct indicated, that the board be allowed to rehear the argument and ask whatever questions the board thinks appropriate and make a ruling with a written decision so that this process can go wherever it's going thereafter. But that's just my position.
Now, this is Member Nylander, and I agree with you, Mr. Chairman. I mean, as you have said, and we've all said, we're in uncharted waters a lot of the time here. So I think in fairness, we should hear the arguments. So I guess I would be supportive of granting the first motion to consider, which is what we're doing. So
With that being said, anyone else wish to enter the discussion as a board member at this point before I ask if there's a motion? If no one else has anything to weigh in with at this point, do we have a motion that anyone wishes to present at this time as to the matter that is on the table, which is the requesting consideration of it?
Mr. Chairman, I would move that this is Member Nylander, I would move that we grant the motion to consider, which is the first motion as stated on the agenda.
Member Drat, I second.
Okay, and that is dispositive motions prior to us going any further in this process. Is that correct?
Yes.
Okay. Any additional discussion by board member or comments? Hearing none, all in favor of that position, please say aye.
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 Motion carries unanimously. We are now in a position to forward with motions 1 and 2. And for the record, because of the way this is handled thus far, are we in a position today? I have to ask the board members if the board members have reviewed both those motions and the attached information, the transcripts and so on. If they are comfortable hearing those motions today, or do we need to set that over? And I would look, if they're not comfortable today, to go forward with that before I even ask council if they're ready to argue those motions today. At the most, set it over to the conclusion of our board meeting, which is set for next week, that we would do at that conclusion. But that would be where I'm at. So I need to find out if the members of our board are ready at this point to hear those. It doesn't mean they necessarily have to make a decision today, but are they at least ready to hear it, that they are versed in the material that's been provided? I, for one, I'm versed with the material. So I need,
Mr. Chairman, I've reviewed all the material. I'm prepared to go forward.
thank you.
I have as well. Member Drat.
You said you have?
Yes.
Okay. We have 3 members, which meets the requirement. As to younger member Merritt, are you ready to go forward today?
Yes. This member Young,
Yes.
yes, I've read the material.
So we have a board that's in posture pursuant to statute to hear. The question now is for our representatives in this matter, if they are ready to go forward.
Yes, sir. Rose Thomas are ready to proceed.
Let's take a curt 5-minute break. We'll come back on the record and let you begin to present.
Okay. You know how I.
Do we have our Zoom board? We have Dennis. If our parties are ready to go forward, we can begin our arguments for the board to consider the motions to dismiss. And for the record, Ms. Rushton, are you going to argue them jointly, or do you wish to argue them separately? How do you wish to do that?
Chairman Douglas, I was planning to go through all of them at the same time. However, if the board would prefer that I split them up, I'm happy to do what is easier for you.
No, this is your opportunity, so I will let you proceed.
Thank you. Again, for purposes of the record, I'm Kimberly Maxon Rushton with the law firm Cooper Levinson, appearing on behalf of Lettuce Test LLC, otherwise referred to as LTL, or the respondents in the matter. As I noted earlier, it is significant to point out for the board the fact that every one of the alleged violations contained in the 2021 complaint occurred in 2019. It's also important to note the fact that when the matter started in early December of 2019, pursuant to an audit and an inspection, that there were requests made by the inspectors for changes. They specifically ordered the respondents to make changes, which they did at that time. That included ceasing retesting of microbials. That happened on December 11, 2019, before the summary suspension for retesting of microbials was issued. Thereafter, upon the submission of the summary suspension, we filed an answer to that and specifically requested a hearing. That is consistent with the law at the time, Nevada Revised Statute 233B. Between the time of the issuance of the summary suspension and the answer and the setting of the hearing date, a statement of deficiencies was issued to the respondent. It contained 13 known violations and 2 possible violations. In response to that, the respondents prepared a corrective action plan that addressed the issues specifically identified in the summary suspension, as well as the 13 violations and the 2 possible violations. Those were submitted to the Marijuana Enforcement Board or Division, and they were approved. And as a result of that, again, the respondents immediately started making changes in order to demonstrate compliance. And then on the day of the hearing relative to the summary suspension, the parties met and decided to forego the hearing and to move forward with the approved correction action plan to lift the suspension. And as I noted earlier, as part of the complete disciplinary process, complete the corrective action plan to the satisfaction of the then Marijuana Enforcement Division. So it begs the question that if these actions were done immediately at the time that they were raised by the auditors during the inspection in 2019, and then immediately following the statement of deficiencies, compliance was demonstrated. That's what the law required at the time. So why are we here?
Ms. Rushton has a point that you're talking about right now, so I better understand the facts as put forth. We had a notice of deficiency. We had a correction action plan. Was that correction action plan in response to a summary suspension of the right to operate at that time? So, or was it just complying with the alleged deficiencies?
In response to your question, Chair Douglas, the corrective action plan was specifically in response to both the summary suspension and the statement of deficiencies. If you look at them, they have the same arguments. The statement of deficiencies specifically pertain to the retesting of the microbials, as well as numerous other violations. And what's important to note is the fact that prior to this board being constituted, the way that the Marijuana Enforcement Division handled disciplinary matters, and I know, and it's in your record, because of the fact that respondents were subject to one in 2017, 2018. They issued the summary suspension, the statement of deficiencies. Again, under the law, it says that if an agency is going to do that without notice, issue the summary suspension, It is part of other proceedings. So the law says that's your disciplinary action. You've been given notice now, and you're on notice of the fact that this agency is proceeding with disciplinary actions against you. And so recognizing that that was the process that was in place since 2017, upon the issuance of the summary suspension, an answer was filed to specifically address those issues and to request a hearing to lift the suspension. Then came the statement of deficiencies, which, as I indicated, was much more expansive, in which a corrective action plan was proposed. And so at the time of the hearing, the objective was, yes, to lift the summary suspension, but it was clear between the parties that we were proceeding with a corrective action plan in order to demonstrate compliance, meet the statutory standard, and complete the matter. That's the way the law read at the time. That's consistent with the actions of the Marijuana Enforcement Division. And it's also consistent with Nevada law when you talk about habit. When an organization or an agency has a pattern of handling matters in a certain way, the parties had a reasonable expectation when we walked into that hearing room, having completed an accepted corrective action plan, that if they wanted a fine, could have asked for a fine at that time. Instead, there was a meeting of the minds to conclude the matter and proceed forward with the corrective action plan, thereby demonstrating compliance, thereby meeting the statutory standard under 233B. And so for those reasons, we believe that the case should be dismissed for what is known in the criminal world as double jeopardy. In the civil world, it's referred to as res judicata. And in Nevada, the Nevada Supreme Court has broken that down into what they call claim preclusion and issue preclusion. And there are certain factors that a party has to demonstrate in order to prove that the matter should be disposed of because it's already been heard. Specifically, same parties to the matter. You have the Marijuana Enforcement Division, i.e. the state of Nevada, and LTL respondents, both relative to the statement of deficiencies in the summary suspension and the 2021 complaint. You have what we would say is a disposition on the merits of that summary suspension, which completely mirrors what you have in the 2021 complaint. So what we're saying is the fact that the matter should be dismissed because back in 2019 and 2020, the respondents demonstrated compliance. It was their proposed corrective action plan in response to the statement of deficiencies was approved by the Marijuana Enforcement Division. The suspension was lifted. The obligation remained with the respondents to continue on the corrective action plan. And then at that time, when those were met, the full suspension was lifted. I would note the fact that in 2020, when we appeared at the time of the hearing, it was only a partial lifting of the suspension. So when that was completed in February of 2020, it's our position that the matter was concluded. We had demonstrated compliance, or respondents had demonstrated compliance to the satisfaction of the Marijuana Enforcement Division, and the matter was over. And in light of the fact that the violations contained in the summary suspension, as well as the statement of deficiency, are the exact same as those contained in the complaint, our position is that the matter should be disposed of based on the demonstration of compliance and the completion of the disciplinary action that started in 2019. The second argument that was lodged by the respondents relative to the motion to dismiss is one called latches. And that's an important equitable doctrine because in a matter like this, when you have no statute of limitations, you have to look at latches as to whether or not the Marijuana Enforcement Division, then turned CCB, took too long to file the complaint. And what I mean by that is the fact that you had all of the evidence. I mean, again, it's obvious in your complaint. Everything pertains to actions that occurred in 2019. So when the audit inspection was done on December 11th, 2019, the state knew what potential violations they were looking at. They were contained in the statement of deficiencies. And one of them that was not contained in the statement of deficiencies that deals with the flower trim designation was specifically ordered by the investigator that be changed during the process, during the audit inspection. So the issues that were raised in writing relative to the summary suspension have been ceased and completed in early December when the agent said, we don't like this, stop doing it. And the respondent said, okay. Then when the agent said, you need a camera, they said, okay. When the auditor who made one finding said, you need the 16 hours of independent training, they said, okay. And all that was done even before the issuance of the summary suspension. So when the summary suspension came, the question was, what more do we need to do considering the fact you told us to stop 2.5 weeks ago and we stopped? But then when the statement of deficiencies came out, and it was much more expansive, as I indicated, that undertaking in terms of being able to demonstrate compliance was costly and time consuming. And as your records, I'm sure, indicate, the respondents adamantly disagreed with the findings of the audit and investigation, both scientifically and legally. But as a former regulator sitting where you are, I can tell you with absolute certainty that doesn't matter. Even if they didn't agree, they have the obligation to demonstrate compliance to the satisfaction of the agency that holds their license. And that's what they did. And so again, it begs the question, when all of that was done in 2020, before you were even in place, why file a complaint in 2021? And what happened during that time that prejudiced my clients is the fact that, one, the evidence, the key evidence was no longer there. We have requested that the samples that were used as the basis for the summary suspension and 2 health advisory notices that called them out by name, those were based on retests conducted by competitor labs. We asked that the samples be preserved and maintained. Never. It was never done. And then when we got prepared for the hearing, we asked for the samples. Never provided to us. The state has an obligation to marshal and preserve the evidence that is going to be used in the case. And they will tell you that it's not important to the complaint. It was important to us. It served as the basis of a suspension. It served as the basis for 2 health notices that called them out specifically. You cannot argue in good faith that those samples were not important. They were evidence that we had a right to inspect. In addition to that, we also lost witnesses. When we came to the hearing in January of 2020, we had the lab directors from the competitor labs. We had the then scientific lab director who had been in place during the audit, and now they were gone. They had left the jurisdiction. Your review of the transcripts in the complaint, there's a lot of discussion about a training chemist by the name of Ozzy, and Ozzy was gone. So there was no way. I mean, they were there in 2020 at the time of the hearing, but by 2021, they were no longer in the state. So we lost evidence, we lost witnesses. And in addition to that, there was a material change in the law. That's the difference between the 453 A and D and 678 where you are now. And the reason why that's significant, members of the board, is the fact that for 2 reasons. One, you have the protections of 233B. And 233B is exactly what I argued earlier in terms of the standard and obligation to demonstrate compliance before you even launch into this process relative to suspension and revocation. The other thing is it denied us the right to do discovery consistent with what we should have been able to do. Because under your new regs, we don't get to look at the investigative files. Under the old regs, we got to see them. And so we were precluded from the ability to see the investigative files that may have contained exculpatory evidence, may have contained more photos and recordings than we believe were presented during the hearing. And we were also denied the ability to call the witnesses who made the decisions relative to the summary suspension and the issuance of the advisory notices. We were not allowed to call either Chief Cronkite or Director Klimas, even though they specifically made the decisions. And during the testimony, it was clear that the investigators/auditors and everything did not have that discretion. So as a result of those things, respondents were not able to properly defend themselves. Evidence was missing, witnesses were missing, material change in the law. There is no reason when they knew everything at the time of the inspection and audit in 2019 for them to have not brought a complaint sooner if they felt like they had to do so. So even though we agree that we submit that the matter was completed at the time of the completion of the corrective action plan, even if they didn't construe it that way, what was the basis for not bringing this action sooner? It was just for the purposes of delay. And as a result of that, it significantly prejudiced the respondents. And therefore, the 21 days of hearing are completely incorrect or inaccurate. They did not allow us we couldn't even call our now scientific lab director. I mean, the case was anything but an administrative hearing in which the rules of evidence are relaxed and the general standard is relevance. No, we were held to pre-hearing motions and obligations in terms of timeliness, and anything that came up in the hearing during the state's case in chief and we wanted to present rebuttal, we were denied. Latches applies in this instance because of the significant and severe prejudice that the respondents suffered. The last point, as I mentioned earlier, specifically with respect to the jurisdiction of this agency to, like, as I indicated, reach back into another agency's now repealed laws and prosecute licensees for disciplinary actions. Specifically, the bill that created this board is Assembly Bill 533. It is a 173-page bill. There was extensive discussion and testimony on this. Member Durrett was a part of that. There was discussion in front of the Assembly Judiciary, in front of Senate Judiciary, and it is replete with statements such as, this is a new organization, this is a new agency, this is where the industry needs to go, and these are the tools that the industry needs via the Cannabis Compliance Board. It stripped the board of the ability to have to adhere to 233B, a material change. It transferred responsibilities to other agencies. For instance, it maintained the ability to audit for tax purposes by the Department of Taxation. The issuance of the medical marijuana cards was preserved for the Division of Health and Human Services. So it's clear when you review the bill specifically what parts were preserved, what parts were replaced, and what parts were reorganized. In her findings, the ALJ pointed to one section, Section 240, as demonstrating the fact that it did carry over, that there was a savings clause that carried over the ability of this agency to continue disciplinary actions. We do not believe that the state's interpretation of that and that the AG's position is accurate. And the reason why is because that same section, as well as the section thereafter, says that upon promulgation of the NCCRs, your regs, that 453A and D went away. So there is specific language that the legislature said where it is preserved until this time. But once you promulgate and adopt those new regs, they go away. And so our position is that at the time that the complaint was filed, it is based solely and exclusively on Nevada Revised Statute 453A and D and Nevada Administrative Code 453A and D, which were repealed at the time of the filing of the complaint. And therefore, the jurisdictional authority of the board was extinguished at that time. And with that, I'd be happy to answer any questions. Otherwise, Chairman, I respectfully request the ability to just follow up and rebuttal.
Any questions?
I do have a question. Okay, so one of the main arguments, just so I follow along, because the arguments developed quite a bit throughout the pleadings, is that 453A and 453D don't apply, but if they did, you would have the benefit of LTL would have the benefit of 233B, and under 233B, you can't have like a temporary summary suspension, lift that, and then proceed to disciplinary proceedings. Is that right?
In part, Member Durrett. So 233B.127 in its subsection 3 specifically states, A, you can't proceed with revocation and suspension until you give the licensee the ability to demonstrate compliance. However, in the instance of a public health or safety emergency, the agency may issue a summary suspension as part of the other proceedings. It specifically says that. And that language demonstrates the fact that the summary suspension is the initiation of the disciplinary action. And our position is that that disciplinary action, consistent with the latter part of the statute, upon demonstration of compliance, was done. And we also believe that for another reason, Member Durrett, is the fact that one, in the stipulation and settlement agreement, it specifically refers to the completion of all corrective action plan that was approved by the Marijuana Enforcement Division. And then the subsequent email from the ALJ Smith, when I asked that the matter be reopened based on the issuance of another health advisory notice. And she said, I'm sorry, Ms. Rushton, the matter's closed. You had the opportunity to go to hearing, the parties settlement and settled it, and therefore there are no other pending matters. The matter is closed.
If you follow that argument to its logical conclusion, then the state would never be able to do a summary suspension to allow the licensee time to kind of clean up, get their act together, get compliant, and then be reinstated while the investigation and the disciplinary action is pending. So that would really hurt the industry, because then they wouldn't be allowed to be reinstated while the disciplinary action is pending. So if that takes 6 months, then you'd be shut down for 6 months, right?
So in response to your question, Member Durrett, it's a matter of agreement between the parties. So under that same provision, it states that the entire matter must be concluded within 45 days. So that specific statute contemplates the issuance of a summary suspension without notice because the agency believes that there's a health issue or a safety issue, but it's part of the other proceedings, and that matter needs to be concluded in 45 days. So that's what the legislature is saying. The intent is not to allow the summary suspension to last 6 months. The intent is to address the specific issue that caused the concern or the agency to believe that there could be one, take them off of the summary suspension if they can demonstrate why they should be, but as part of the other proceedings, go with those at the same time and complete them within 45 days. It's not supposed to be a long, drawn-out process.
So your position is that the disciplinary hearing would have had to happen within 45 days as well?
Yes, ma'am, that's the law.
I do have one more question. I think you answered it. So I was wondering why you did send the letter to preserve the samples, but your position is that that was related to the public hearings, not
correct.
an ongoing investigation.
As noted in the state's opposition to the motion to dismiss, it did state that in February. So again, you've got the microbial testing that the investigators say we don't like during the hearing or during the audit inspection, December 9th through the 11th. Respondents say, okay, we'll stop. They stop. 2.5 weeks later, you get the suspension for that same reason, even though the action and the practice has stopped. Then we go through the process relative to the hearing, the statement of deficiencies, the corrective action plan, and out of the blue, in February 2020, there's another health advisory notice issued. Again, at that point, we say, what's the basis of it? Please preserve this. We don't understand. And then again, you see in the record and everything, my request to Administrative Law Judge Smith as to can we have a hearing on the legal authority to issue this at all? I mean, did the Marijuana Enforcement Division have the authority to issue a health advisory notice? And two, if they did, why in this instance when the practice that they're complaining of stopped on December 10th, 2019?
I do have 2 more quick questions. And this might be naive, but why not bring the witnesses out of state? And can you point to what it is under NRS 453 A or D, or that if that approach was taken, that would allow you to have access to investigative files?
So specifically the witnesses, actually, we did subpoena them out of state and they have no obligation to return to the state. And so Mr. Ruiz, Ozzie Ruiz, we didn't know where he went. He left almost immediately after the matter started in early 2020. The then scientific lab director, Hafe Yin, had left the jurisdiction and made it very clear she was not coming back. She had moved out of the jurisdiction. She was not going to come back. And then the other 2 lab directors that we had subpoenaed in 2020 that were present had moved across the country and said, we're not coming back. And so with respect to the obligation to preserve the evidence, I mean, that falls under, I believe it's 233B, but I can certainly look at 453D, A and D and give you the specifics.
Okay.
But again, remember, Durrett, the question was, is that, you know, if the samples were tested by the respondents and then 2 months later or weeks later tested by a competitive lab, and everything. We wanted to know chain of custody, manifest, why it was a competitor lab versus the Department of Agriculture as 453D specifically requires. And we also wanted to retest against them because in that process, you remember, we're talking about a strain. So don't know if the competitor labs went to the cultivation sites and took their retention sample, or if they went to the dispensary. From what we learned during the hearing, it was both. But in that process, another lab then went out and retested a third time, and the results were exactly the same as LTL's. And so it was very important for us to have access to those samples so that we could demonstrate that they were not comparable, and two, the fact that they were not properly maintained, or there was no chain of custody or manifest to ensure their integrity.
Any other board member before Ms. Rushing sits down? Ms. Rushing, before you sit down, I'll give you something that I don't expect you to respond to at this time, but when you get back up, a question you can respond to. One, you're the moving party, the burden is on you, so articulate what your burden is to do. Secondly, whether or not in this motion, even if the motion isn't granted, are you precluded from raising any of these issues at a hearing on the individual counts that are pertinent? So when you get back up.
Yes, sir. Thank you.
Ms. Balducci or Mr. Rath?
Good morning, Chair, members of the board. For the record, I am Senior Deputy Attorney General Ashley Balducci on behalf of the petitioner. I will be addressing the arguments in respondent's first motion to dismiss, which included res judicata, issue preclusion, claim preclusion, collateral estoppel, and latches. And Mr. Rath will be addressing the legal argument regarding what procedure and substantive law should apply. As you have all noted, you've read and reviewed the briefs, the transcripts from the hearing, and the hearing officer's ruling that she made on April 16th, 2021. The board should, like the hearing officer ruled, deny respondents' motions to dismiss for the reasons stated by Mr. Rath and for the reasons that the hearing officer ruled on April 16th of last year, but also for the following 5 additional reasons. First, there was no global settlement agreement that resulted in a full and final adjudication of all violations being investigated. If you read the documents in the parties' moving papers, you will see that these documents do not say what respondent or respondent's counsel argue they say. I attached a declaration to petitioner's opposition. It's Exhibit 9. And in lieu of providing the emails, which contain confidential settlement discussions, I did a declaration and attached the emails redacted. But I brought with me unredacted versions of those emails if the board's inclined to want to see them. While there were 2 global settlement offers made during the summary suspension to respondent, both of those offers were actually rejected. And 2 of the documents that respondent is now relying on to say that they were a statement of deficiencies, which it was a statement of deficiencies, but it was actually part of one of those global settlement offers, and it was attached to one of those emails. And then the other document that respondent relies on was titled Response and Rebuttal to Corrective Action Plan. And I think, to be specific, it's Exhibit 2 to the respondent's motion. It doesn't say approved corrective action plan. It says response and rebuttal to proposed corrective action from Cannabis Nevada LLC. Now, that document also was attached to an email I sent involving confidential settlement discussions. If you read the stipulation and order regarding summary suspension, and that's attached to respondent's motion as Exhibit 3. Respondent argues this is a settlement agreement that resolved all violations being investigated, but the term settlement agreement is nowhere in this document. Also, this document lists corrective action that respondent needed to do to lift the summary suspension. There's no other corrective action plan, and none of the violations identified as still being investigated are referenced in this document. It says, which include the corrective action plan identified below, 1 through 6. The document does not state that the division would not pursue any further disciplinary action or proceedings, and the lifting of the summary suspension was not automatic. So the summary suspension was not done in December of 2019. It was partially lifted in order for respondent to do the corrective actions listed in the stipulation, and for the division to then later re-inspect and confirm that respondent had complied and had followed through. If you go back to my declaration attached to petitioner's opposition as Exhibit 9, the emails between counsel are included, and again, they're redacted. And I can tell you, respondent's counsel did try to call the stipulation order regarding summary suspension a settlement agreement, and also proposed other terms, all of which the division rejected. I also articulated in an email prior to even signing the stipulation that this is not a settlement agreement, that it's a stipulated corrective action plan to lift the summary suspension, and that respondent was still being investigated. Second, an order of summary suspension is inherently different from a complaint for disciplinary action. For example, an order of summary suspension is when the agency makes a finding that public health and safety imperatively require emergency action. For a complaint, the agency, there must be a finding that the agency proved by a preponderance of the evidence that the violations alleged. Additionally, the order of summary suspension becomes effective immediately, and notice of the order is provided to the licensee only after it's issued. A complaint for disciplinary action does not impose discipline until after the licensee receives notice, a hearing, and the board adjudicates the disciplinary action. There is also no statute of limitations on an agency or when an agency may bring a complaint for disciplinary action. As Mr. Rath will argue, the procedures of Title 56 of the Nevada Revised Statutes and Nevada Cannabis Compliance Regulations apply to the CCB's complaint. But even for the sake of argument, if it did not, respondent cannot argue that NRS 233B, NAC 453D, or the NCCR that a summary suspension precludes a revocation or other disciplinary action. The plain language of these statutes and regulations contemplate further proceedings for revocation or other action. Third, if there's no global settlement agreement, there's no res judicata, there's no collateral estoppel, there's no claim preclusion, and there's no issue preclusion. And none of the cases relied on by the respondent in the briefs and involved an administrative agency applying res judicata to its own administrative actions. And even for the sake of argument, res judicata applied, the stipulation order regarding summary suspension did not result in a full and final adjudication of all the violations being investigated. As such, none of these legal doctrines apply to preclude the CCB's complaint. Fourth, the CCB did not engage in ad hoc rulemaking when it issued a cease and desist letter to respondent. This argument is not a basis to dismiss the CCB's complaint, and the CCB's inspectors did not engage in ad hoc rulemaking when they issued the cease and desist letter, and particularly because it was for a violation of Nevada law. Respondent was routinely reporting results for pesticide mycotoxin testing when the quality controls were failing, which precludes accuracy and has the potential for endangering consumers. Fifth, the doctrine of latches does not apply, and the hearing officer in her ruling did make findings on latches. She said there's no delay and no actual prejudice. There was no delay. The investigation took a year to complete, and a month after the investigation was completed, the CCB approved service of the complaint. The record of this case contains thousands of documents that the inspectors had to go through. And at a disciplinary action, you have to prove by a preponderance of the evidence the violations. You need evidence. And no actual prejudice has been shown. There's no state or federal due process right to discovery in administrative proceeding. And that's Duchess. It's cited in my brief. Respondent was never entitled to obtain the retested samples under the law, and petitioner never used the retested samples as evidence. As for the unavailability of certain witnesses, respondent's former scientific director, Haifei Yin, was subpoenaed by petitioner, by Chris and I, or Mr. Rath, sorry. And because of delays related to service of the subpoena, respondent objected and excluded her testimony. If not having Miss Yin's testimony was so prejudicial to respondent, then why did respondent exclude her testimony? As for the other two witnesses, Brenda Shalou and Daryl Johnson, and I think it was Ozzy, as for them, I'm not even sure if there was a subpoena issued for Ozzy, but for Brenda Shalou and Daryl Johnson, there were. And if petitioner figured out how to subpoena Miss Haifei Yin, who was living in California at the time, I'm pretty sure respondent could have done it as well. And it's not the CCB's fault that these individuals may or may not have moved out of Nevada. So absent delay and actual prejudice, the doctrine of latches does not exist to preclude the CCB's complaint. I respectfully request that the board really examine the documents against respondents' arguments. The board does not need to accept respondents' strained interpretation of what the documents say, because the documents speak for themselves. For these reasons and the reasons provided by Mr. Rath and in the hearing officer's ruling on April 16th of last year, the board should deny respondents' motions to dismiss. Thank you.
Any questions before Ms. Buckentucci sits down? Thank you.
Chair, members of the board, good morning again. L. Christopher Rett, Senior Deputy Attorney General. I will be arguing the second motion to dismiss, the one in which it's essentially claimed you can't charge this respondent with anything. However, before I get there, I do want to address the chair's question to Ms. Rushton previously on the standard for a motion to dismiss. As you're all aware, the standard for a motion to dismiss is extremely high. It's higher than that of a motion for summary judgment. Case law tells us that the respondent or the defendant has the burden to show that the other side cannot prevail on any facts alleged. Respondent cannot meet that burden on either of the motions to dismiss, including the second motion to dismiss, which is essentially an attempt to find a legal loophole to get around their thousands of violations, but that legal loophole doesn't exist. I would incorporate all the arguments I've previously made. You've seen them in the transcript. You've heard them multiple times in the motions. I'm going to try to cut to the chase and add a little bit of explanation to what's previously been stated. The hearing officer appropriately ruled that respondents' reading of the law that they could not be charged for their numerous violations under the NAC charging regulations can only lead to absurd results that the legislature never intended and would not allow for the seamless and continuous regulation of the cannabis industry that the legislature clearly did intend. As argued below, the violations at issue occurred when NAC was in effect. Respondent has already admitted that. The CCB appropriately charged respondent with the regulations that existed at the time the violations occurred. It could not charge them under the NCCR because those regulations didn't even exist at the time of the regulations, at the time of the violations, sorry. If we can't charge them under the NAC as they claim, let's talk about what would have happened if we had charged them under the NCCR, if that was even possible. If we had charged them under the NCCR, respondents' argument here today would be that the CCB had applied its new regulations retroactively and unfairly prejudiced respondent with higher penalties that go with the NCCR. In any event, the language of the NCCR for the violations alleged in our complaint under the NAC is exactly the same as the language in the NAC for the same violations, but with one key difference. I'd like to give a couple examples to really bring that point home. First of all, respondent was charged with many violations of NAC 453D.9053A3 for making intentionally false statements to the Department of Taxation. The NCCR analog is NCCR 4.1351A3. That states exactly the same thing, but with respect to the board. One says intentionally making false statements to the department. The other says making intentionally false statements to the board. Thus, the substance of the violations are essentially the same whether the NAC or NCCR is used. They're both looking at making an intentionally false statement to a regulatory body. However, if we had charged under NCCR, respondent's argument now would surely be that it never could have made a false statement to the board in 2019 because the board didn't exist then. There is no NCCR for making a false statement to the department, so we could only charge them under the NAC. According to respondent, we really couldn't charge them under the NAC or the NCCR with providing false information to any regulatory body, so they should just get away scot-free. Obviously, the legislature didn't intend that. This is true for other charging statutes. We made alternate charges. They unintentionally misrepresented facts to the department. It's the same thing under the NCCR, only it says board. Respondent was also charged with multiple violations of NAC 453D.9053D8 for allowing activity that violates the law of the state. The NCCR analog is 4.0501A7, which says exactly the same thing. But again, the issue here is that these violations took place back in 2019 when neither the CCB nor the NCCR existed. So how can we charge them with a violation of a regulation that did not exist at the time the violation occurred? That would have been argued here if we'd used the NCCR. So what are we left with under their reading of the statutes, regulations, and savings clauses? It's a situation in which they skate on thousands of violations because the CCB cannot complete an investigation that started under the Department of Taxation, finished under the CCB, and was filed when the CCB took over regulatory authority to complete this enforcement action against this licensee. That is an absurd result, as we argued multiple times below. The fact is, this licensee benefited from being charged under the NAC because the penalties were lower and the violations charged matched the violations committed at the time they were committed. For instance, they made a material representation to the department, not the board. Their reference to the savings clause is misleading. There's really two parts to the savings clause. One is prospective and one is retrospective. The prospective part is laid out in NCCR 1.010, which they do cite in their moving papers. That says that while the CCB is using the old regulations which they had to do before the NAC was adopted, the term CCB would replace all references to the Department of Taxation. That makes sense only when the CCB is using the old regulations to apply to violations which occurred after July 1, 2020, but before the NCCRs were in place. Again, that's part of the savings clause. It's prospective. It's looking at violations committed before the NCCR goes into effect. The second part of the savings clause is really the key one here, and I'm going to read it. It states, any action taken by the Department of Taxation or its constituent parts pursuant to Chapter 453A and 453D of NRS governing the licensing and regulation of marijuana establishments and medical marijuana establishments before July 2021 remains in effect as if taken by the Cannabis Compliance Board or its constituent parts on or after July 1, 2020. What respondent wants you to believe is that any action does not mean ongoing investigations. An investigation of a licensee, however, is certainly an action governing the regulation of marijuana establishments. Likewise, a disciplinary action is also an action governing the regulations of marijuana establishments. Both investigations and disciplinary actions must be allowed to proceed, as that was the intent of the legislature. The savings clause is the enabling authority for petitioner to use the NAC charging regulations in this case. Respondent claims that there's no legal authority for our argument that any action includes investigations and disciplinary actions. Then what does it include? The legal authority is the plain language of the savings clause itself. Respondent provides no contrary legal authority for that proposition. That is respondent's burden as the moving party in the motion to dismiss, and it's failed to do that. It only makes sense that the legislature intended the continuous and seamless regulation of the cannabis industry, inclusive of investigations and disciplinary actions, and that is exactly what was done here. The appropriate regulations were used to charge and discipline this respondent. There is no donut hole in time where you cannot use either the NAC or the NCCR to proceed against a violating licensee. Now, briefly on to procedural issues. As the hearing officer found, and as the United States Supreme Court has also determined in the Landgraf case, changes in procedural rules from the time of the commission of the violation to the time of the adjudication of the violations are allowed and do not constitute retroactive application of a statute or rule. Respondent never addressed the Landgraf case in its reply brief or in any prior oral argument. Thus, respondents claim that if it was charged under the NAC, the hearing had to have been held under NAC 453D is meritless. Despite all the talk of 233B, there is a procedure, or there was a procedure, under NRS 453D for disciplinary hearings as well as summary suspensions. Under NRS 453D.5 or .940, a hearing would have had to have been held before a hearing officer, which would have been the tax ALJ who heard this matter anyway. Under NAC 453D.988, that hearing officer would have held a hearing and issued findings of fact and conclusions of law. That's exactly what happened here anyway. There was some discussion about discovery, and they would have gotten extra discovery under the prior rules. That's just not the case. As Ms. Balducci indicated, the Duchess case clearly indicates there's no right to discovery in administrative actions. And if you look at NAC 453D, it also says you don't get any of the investigative file unless we produce it. And that's for summary suspensions. It doesn't allow any discovery under the regular disciplinary process. The difference here is that under NAC 453D.944, respondent could only file an appeal of the hearing officer's decision to the Nevada Tax Commission, which could only be done under certain grounds. Under the NCCR procedures which we use, respondent actually gets to have a full adjudication in front of this board to affirm or alter the hearing officer's finding of fact and conclusions of law. And regardless, the Nevada Tax Commission no longer hears cannabis appeals, so there would effectively have been no way for an administrative appeal. Again, respondent gets the benefit and more due process under the substantive law of the prior statutes, which we're allowed to use due to the savings clause, and under the procedural rules we are using under the NCCR. The only reason this motion's been filed is because respondent knows that it has committed thousands of violations and is trying to find some legal loophole to avoid the discipline it deserves. This motion to dismiss does not provide that legal loophole, and the denial of the motion to dismiss should be upheld. Any questions?
Question by members of the board.
I have a question.
Yes.
So what is your response to the argument that if 233B applied, the disciplinary hearing would have to happen within 45 days?
That's for a summary suspension. I don't believe there's anything in 233B that says a disciplinary action has to take place in within 45 days. That's a summary suspension. Their summary suspension is over.
So the position is that I think it's 0.127, 233.127, subsection 3 is that only applies to summary suspension.
Yes.
Disciplinary actions are a separate matter.
Yep.
That section doesn't apply to disciplinary actions.
Yes.
So which statute would apply to disciplinary actions outside of 233? So if you're looking at 233,
we're looking at NAC 453B because that's what they would be going under. And I'll make another comment too. Under the NCCR, disciplinary actions are supposed to take place within 45 days. They waived it. They stipulated around that 45-day rule. In this case.
Okay. And then the other question I have is the state's position that there is no right to review the investigative file even under 453A or 453B or any body of law.
Correct. There's no right to discovery in general administrative actions under the Duchess case.
I do have one more question for the state, and it was actually for Ms. Balducci.
Do you have any more questions for me? And then I'll have her come up.
I don't.
Does anybody else?
Hear none.
All right, thank you.
So I looked through a few times at the exhibits and I was looking for the place where it said this is still under investigation or this does not apply to can you just read that very limited part where it says that? I think
it's actually in one of the redacted emails and I have them with me. I have copies, but it was an email I had sent on January 23rd, 2020 at 3:24 p.m. to Ms. Rushton. This is a stipulated corrective action plan to lift the summary suspension and not a settlement agreement. We struck the language yesterday from the SAO because our client did not agree to that term. As previously communicated to you, the department is not stopping its investigation.
Thanks.
Is that it?
Me too. Thanks.
Thank you. Ms. Rushton.
In response to your question, Chairman Douglas, I believe that Mr. Rath did answer it, but specifically for the record, the standard in this matter is a preponderance of evidence. It's set forth in NCCR 4.120. It is also the same standard as contained within the prior Administrative Procedure Act that was applicable at the time, 233B. In addition to that, I would note the fact that, and if I could start from the last argument relative to the preservation of the ability to proceed under 453A and D. As it applies to the land grab case, that, like the bill itself, is a very lengthy case and goes into a very substantive analysis relative to retroactivity and how it applies in different instances. And in doing so, the court gave a number of examples and specifically talked about an example akin to the one we have here, where you have a disciplinary proceeding or a what I would say a penal thing. So it could have been a criminal in which you had an action that had been contemplated but had not been completed. And you had actions that were then raised after the change in the law. And the court went into a very exhaustive review as to the difference. And in support of this, in that case, the US Supreme Court specifically held, relying on our consistent practice, we order the action dismissed because the jurisdictional statute under which it was filed was subsequently repealed. It also said that the court had analyzed multiple instances in which retroactivity of a statute can occur and held such acts that predate the repeal of a statute to be now of no movement. That is what the Supreme Court case that they rely on specifically says. You had the opportunity, you didn't understand the obligations that in the law, it specifically stated 453A and D go away. Your own regulations, Reg 1 and Reg 4, specifically talk about that. Under your declaration of purpose under Reg 1, it talks about the fact that the regs, when put in place by the Cannabis Board, will replace the repealed regs under NAC 453A and D. And then in NCCR 4, it goes on to state your authority to bring disciplinary actions of this title, of this chapter. That's 678 A and D. That is not 453, completely separate. So your regs evidence the fact that when the statutes and the regs were repealed, they went away. And for those reasons, we respectfully submit that the jurisdiction was lost.
Does that encompass your position as what was asserted by Mr. Rath as the term action?
So I understand exactly that specific language under section 240. And to that, Justice Douglas, I would say no. That infers that you know that there is an action taking place. There was a good faith belief by the respondents at the time that they demonstrated satisfactorily to the medical and the Marijuana Enforcement Division that the matter was over. The action was over. It was done. And therefore, if there was an ongoing investigation, it doesn't constitute an action because we didn't know. And so for those
in light of that, and also your take on what Ms. Balducci just provided, this email and the language in it in terms of settlement versus it's not the proper term, resolution, so your business could continue, go back, be open. Where are we at on?
So in order to lift the summary suspension, which identified 2 specific areas dealing with microbials. So that is what had to be demonstrated by the respondent in order to lift the summary suspension. But to complete the matter, we had to demonstrate through a corrective action plan and thereafter the actions to meet the terms of the corrective action plan that we had demonstrated compliance. That was the standard. I keep coming back to this because it really does beg the question. If compliance was demonstrated by the respondents and that was the law at the time, why are we here? Is it simply over a fine amount? And if it is over the fine amount, why couldn't have that been offered to the respondents at the time of the proceedings? So we reject one amount and everything, and that's
I
the end of it.
understand that portion, but it gets us into an area that we don't want to get into, which is why or why not
Right.
the settlement discussions or agreements seem to break down. That's kind of outside the record at this point.
But
so we're in this never land of you're wanting to assert there was a full settlement. We don't have a settlement document, at least that I'm not aware of. If you can point to one, I'd appreciate it. But we're in this question of how these matters were being handled then.
Yes, sir.
And that's what you're giving to us. So I appreciate that.
So specifically, the stipulation and settlement agreement references the corrective action plan. So you've got the statement of deficiencies, you have the respondents' proposed corrective action plan, and then you have the approval from the Marijuana Enforcement Division of that plan. You have the time set for the hearing on the summary suspension. We sat there as parties and talked about resolving the issue. And the decision was, okay, if you're going to follow through with the corrective action plan, and that's what you're going to do, we will partially lift it. And then upon demonstration that you have satisfied the other parts of the corrective action plan, we will fully lift the summary suspension. We sat right there and said, anything else? Is there anything further you need from us or that we are expected to do? That was it. And then when we felt that the state had not met its obligation under the settlement agreement, and we went back to the ALJ and said, can we have a hearing on this? We don't believe that they've met it. These other issues keep coming up. Can we have a hearing? And she said, no, the matter's closed. You guys had a right to a hearing. The matter is closed. We had no other avenue to seek any type of relief relative to this. So when the hearing officer says, I'm done, the matter is closed, it's done, what other inference are we to draw than the fact that the case is closed? I mean, it was consistent with the way that the matter, the one and only matter, well, there had been an issue in 2017 that carried over into 2018. Summary suspension immediately gave us a statement of deficiencies, showed up at the hearing. We talked with then Director Pupo. He said, that's fine, $1,000 fine, you're good to go. That was it. Year later, statement of deficiencies, corrective action plan, you're fine. That was the pattern. So when you have an email from counsel saying, this isn't, you didn't do what we wanted you to do, that's a threat. That's government extortion. That is not an indication of the fact that the action is continuing. We believed in good faith that the action had been completed. And the reason why is because the law said that you as a privileged licensee have the utmost obligation to adhere to compliance, to demonstrate compliance. And we adamantly disagree with the opinions of the staff. Scientifically, legally, we do not agree. But it doesn't matter because the law says you must be compliant with their directives, not your own. Follow their directives. So when they said to be compliant, we did it during the audit and inspection. We did it in response to the SOD. What more did you want? What more was expected? And you have to understand too, that when you talk about the pattern of the Marijuana Enforcement Division, the one and only disciplinary action we've been subject to was a $1,000 fine. The only one we'd even potentially heard of was in the realm of like 20,000. I mean, we did not think that the actions that they complained of or that the staff complained of rose to a level of warranting a summary suspension. But we recognize the importance of demonstrating compliance. And that's what they did. And we believed in good faith when they were fully lifted off of the summary suspension that we have satisfied the state relative to compliance, and that was the end of it. And so every time the state calls and requests information or documentation, is every licensee going forward to assume that they're subject to an investigation? I mean, it is an obligation of licensees to be responsive to the regulators. If they ask questions, you give them the information. If they come out and they want things, you give it to them. That's what holding a privileged license means, and that's what they did. And so for those reasons, there is no reason to continue this. We believed, again, in good faith that the matter had been concluded because we met the letter of the law. And with respect to the latches, there is no way to phrase it other than the fact that as a seasoned administrative attorney, the way that this case was handled was more akin to a criminal prosecution. The standards, the manner and the tone of it, it was not an administrative hearing in which the parties are supposed to, again, work together with the objective of ensuring that that licensee can demonstrate compliance. It wasn't like that at all. No settlement discussions once the complaint was filed, no collegiality, nothing. It was, you're bad, we want you out, that's it. And yet, no matter how much my clients did to demonstrate compliance time and time and time again, we still ended up with a complaint in 2021, readdressing the same issues we addressed in 2019 and early 2020. The measure of discomfort that the Marijuana Enforcement Division wanted LTL to suffer and feel, they felt. And it is continued until today. How long does a matter have to go on, and how much compliance do you expect your licensees to do and demonstrate? And when they say it's satisfactory, that the compliance is satisfactory, why continue the matter? We respectfully request that you dismiss this complaint, primarily for that reason. My clients have repeatedly demonstrated compliance. We also ask that you really consider the fact that while the weight of dismissal may seem like a very high threshold, when you look at the fact that the case was dragged on, and again, summary suspension, never had the right to question anybody as to what was actually the health issue that prompted that. Health advisory notices that called them out. Look at your other health advisory notices. They don't call out the labs. They called out this one. The measure of discomfort that my clients was inflicted upon them, I guarantee you, is greater than any fine you could have assessed against them. It's been 3 years of dealing with this case when we made immediate changes in order to appease the state. Thank you, and I'm open to any questions that you may have.
Questions by members of the board?
Thank you.
There's been no questions. Thank you.
Yes, sir.
I want to take a short 5-minute break to allow the board members to kind of push their own thoughts together before we open up discussion on the record. See where we're going at this point. So we lose Dr. Young, or are we still? Okay, great. We're back on the record. 3 board members who are present in Las Vegas, 2 that are on Zoom, concluded arguments by our parties in this case as to the motions and motions 1 and 2 for motions to dismiss. Time for discussion by the board. Before we get into that, I'd ask counsel for the board to it would make sense to reread 233B.
Thank you, Rosalie Bordelev, with the Attorney General's Office for the record. I just thought there's been a lot of talk here regarding a specific provision of NRS Chapter 233B. So I thought I'd just, for those board members who don't have a computer in front of them, read that provision to you so you know exactly what it says. And this is NRS 233B.127, subsection 3. It says no revocation, suspension, annulment, or withdrawal of any license is lawful unless before institution of agency proceedings, the agency gave notice by certified mail to the licensee of the facts or conduct which warrant the intended action, and the licensee was given an opportunity to show compliance with all lawful requirements for the retention of the license. And then the next part is the summary suspension language that's been discussed. It says if the agency finds that the public health, safety, or welfare imperatively require emergency action and incorporates a finding to that effect in its order, summary suspension of a license may be ordered pending proceedings for revocation or other action. An agency's order of summary suspension may be issued by the agency or by the chair of the governing body. And it notes that if it was the chair would need to recuse. And then as to the timing, it says proceedings relating to the order of summary suspension must be instituted and determined within 45 days after the date of the order, unless the agency and the licensee mutually agree in writing to a longer period. And I can reread any portion of that too, if you guys. I know it's.
The 45 days that you just spoke of was as to the suspension?
Yes, it says proceedings relating to the order of summary suspension must be instituted and determined within 45 days.
All right. Thank you. For the members of the board, we're kind of open discussion on the record as to where we're at this date. I have something in mind, but I wanted to hear other thoughts of individuals as to kind of where we are today, things that people are scratching their heads about or are concerned about, or something that you feel strongly about. This is the time to hear it, because we have to eventually come to a decision as to the 2 motions that were presented to us today and what we're going to do with them.
Yeah, Mr. Chairman, this is Member Nylander. So I wish, I've said this previously, I wish we didn't have these legacy issues hanging around, but the fact of the matter is we do. And while I feel like we've gotten down to, whittled it down to a small amount in front of us. This one is very unique, and it's part of a transition from another agency to our body. and we've now developed, I think, a really good staff and policies and procedures. But we have a motion to dismiss, which, I think both parties have briefed it, and oral argument is in place. And having gone back and read the transcripts again from the hearing, the ALJ, I think we should hear the case on its merits, because we've been sort of touching around the edges of the merit in dealing with this motion. But I don't think that I don't think the burden has been met as far as a dismissal. I mean, we have this giant record in front of us from the whole hearing process, and the normal, course would be to, have a hearing on the merits. So that's kind of where I'm at. I think the record in the hearings speaks for itself. And so as far as what's the threshold for a motion to dismiss, I don't think it's been met. So that's sort of where I'm at. But I could be persuaded either way, because there are questions of law in effect. And, both parties made good arguments in terms of, which law should apply, which law shouldn't apply. But the savings clause is kind of what's putting me over the threshold. And how could we be, effective regulators if we didn't have a savings clause that allowed, matters to continue as the regulatory authority transitions. So that's sort of where I'm at.
Thank you. Any other board member wish to say anything in terms of kind of their feeling?
Member Drett, I agree. This is just basic highlights. I think it'll be fleshed out a lot more in the order, I'm assuming, but I don't think that the legislature's maybe inartful language amounts to repeal of 453A and 453D in a sense that you couldn't then pursue actions that were pending at the time. It does say actions pending, so it kind of revolves around what's the definition of an action. And I don't think that the legislature meant to just give a free pass to anything that was pending at that time. I do think the parties would have been on notice at that time that it was occurring. I don't think it's reasonable to believe that your matter goes away. And so if those do apply, then 233B.1273 applies, and I don't believe that requires the disciplinary hearing occur within 45 days. It doesn't say that. And I think the AG's statement that it's not a settlement gave notice that it wasn't a settlement. And there's one other, just two more points I want to make. That you can't say that we can't give licensees the opportunity to lift the summary suspension and correct what's going on and then not do a disciplinary hearing later, because that system wouldn't benefit the industry. And lastly, I am sensitive to the respondent's statement that this was pursued like a criminal case, because I don't think these matters should be pursued like criminal cases. I don't see how it was necessarily here, and I don't think that's the issue today. But I do think that's a good policy discussion to have at some point.
Anything else for the record? I've read the material, I listened to arguments today, and the arguments today, as the motion to dismiss, gave me a little pause, but probably not enough pause to want to grant that motion. However, I want to take a better look based on arguments that were offered today at what we had before us to see if this is applicable. I know what the burden is of the party and the motion to dismiss. But even though they've had their hearing, they have the opportunity to come back before us as to their position of objecting to the recommendations. I'd like to hold this matter over until our board meeting coming up in a week, I guess, next, depending anyway, at the conclusion, and so that I feel more comfortable, unless other board members disagree with where we're at, because we need to make an adequate record of why we're doing what we're doing. And that's so that's kind of my unreadiness, but I could be persuaded otherwise.
Mr. Chairman, this is Member Nylander. No, I mean, there's a lot to consume. So if we have some more time to think about it, I don't think that's prejudicial to anybody. It's in the best interest of the state and what's fair to both parties. So yeah, if you want to hold it and let us think about it some more. I know there were points raised today that I hadn't thought of previously. So having just consumed the written material, I think it was helpful for me. So I would support holding it, till our next meeting or whenever you think it's appropriate.
I'd like to get this back, just continuing the discussion. Holding it, I'd like to get this back to us as quickly as possible while it's still fresh and doesn't go down the road, because there's a lot of material, a lot of pertinent points. We heard argument, it's still fresh. We reviewed the material, it's fresh. And so I don't want to refresh myself as to this portion in a month or month and a half. So what is the date of our board meeting for next week?
Tuesday, September 27th.
And I would make a motion that we continue this hearing for the formal resolution, the voice resolution and direction until September 27th at the conclusion of the regularly scheduled board meeting. We would have a continuation of this hearing at that time.
This is Member Nylander. I would second that motion.
We have a motion. We have a second. Do we have an additional discussion? Hearing none, all in favor of that, please say aye.
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 Any dissent? Any abstention? Motion carries. We'll reconvene September 27th at the conclusion of the regularly scheduled meeting of the board. And that meeting, the regular meeting, starts at 9 o'clock on that date. This would be following that. And I thank the parties for their arguments today. We have on our agenda one last item, which is our requirements, a second public comment period.
Is there anybody in Las Vegas wishing to provide public comment at this time?
Good morning, board. Good morning, Paul Michael Burgess for the record. Chairman and Douglas, distinguished board members, the Executive Director, Tyler Cannabis. I would like to thank the CCB staff for their hard work and their thoughtfulness on the webinar online application for the cannabis consumption lounges. That does a lot for everybody. I understand that the application will open on October 14th through the 27th. So that's a big thing going on in the community. We want to thank everybody, give you a shout out for your hard work. I know there's a public comment, but I have a question in there. As the CCB represents the state, is it okay for a private business to collaborate with the CCB for federal funds or federal grants that are being put out that have to do with cannabis in this business? So are you allowed to collaborate for federal funds? Other than that, thank you for your time.
Can't really answer the question. You need to talk to Mr. Klimas after the meeting.
Happy to do so. Is there anybody else in Las Vegas wishing to provide public comment?
Anyone from Northern Nevada?
No, sir, Mr. Chairman, no public comment in person.
And that being the case, public comment is closed. That takes us to the last item on the agenda, which is to recess this meeting until the call on the 27th of September. We're in recess.